Good afternoon, good evening, and good morning. Welcome to this event jointly hosted by the Queen Mary Intellectual Property Research Institute and the Intellectual and Industrial Rights and Application Center, FISAUM, at the University of Ankara. My name is Duncan. I'm the director of the Queen Mary Intellectual Property Research Institute. We're very happy to have you here today for our webinar on waiving IP for COVID-19 related health products and technologies. We've got a great panel of speakers. The session is going to be moderated by my colleague, Professor Arzu Oğuz from FISAUM, Ankara University. The arrangements for today's event is that the webinar will be for 1 hour and 30 minutes. We will be hearing from our distinguished panel of experts, and after the three panel members, I'll be returning to you as a panel member myself to give some comments and suggestions about what might happen in the future with the waiver for IP proposals. So in terms of your participation, we would very much like you to use the Q&A function to post your questions to the panel. And the format will be that after the 4 panel presentations, we will then have a moderated discussion. So Professor Oğuz will be selecting questions to put to the panel. We won't be taking questions between the various presentations. We'll keep those all to the end. So without further ado, I will hand over to my good friend and colleague, Arzu Oğuz from Ankara University, who will be moderating today's session. Arzu.
Thank you very much. Dear guests, today we got together for a joint organization of the Queen Mary Intellectual Property Research Institute, Queen Mary University of London, and the Intellectual and Industrial Property Rights Research and Application Center, FISAUM, Ankara University, where I serve as a director. COVID-19 has had a negative effect in our lives for more than a year now. We were distanced from our beloved ones and places. Nevertheless, it brought about new practices too. For instance, as it is the case today, we organize a meeting in cooperation with an institution in another country and with the participation of panelists joining from different countries. I am delighted to be together with my dear friends Duncan Matthews and Burcu Kılıç, although only in virtual environment. Our theme today is without any doubt a very current and attractive topic, waiving IP for COVID-19 related health products and technologies. Our distinguished panelists are going to provide insights into this issue and going to address different aspects accordingly. I owe a debt of gratitude to my dear friend, Professor Duncan Matthews, who always offered unique help and friendship and who was willing to cooperate for this organization despite his tight schedule. He has summed up the aim and scope of the organization quite nicely. Today's organization is going to evaluate current issues related to intellectual property waiver in the context of the COVID-19 pandemic. The webinar is going to focus on particularly the proposals from South Africa and India for a TRIPS waiver of IP rights and potential support from the US in terms of COVID-19 vaccines and counter proposal of the EU. Our time is limited, therefore I would like to give the floor to our first panelist without any delay, Dr. Burcu Kılıç, Research Director, Access to Medicines Program, Public Citizen. Please, Burcu, the floor is yours.
Thank you, Arzu. Let me put my presentation up. And before I start, I have to say that it's such an honor to be here because Ankara University is my law school and Queen Mary is my my university for the PhD. So it's such a privilege, like, you know, Ankara University and QMIPRI, here I am. So let's talk about the waiver. But before we talk about the waiver, let's talk about what's happening in terms of global vaccine timeline. So this is exactly what's happening. I don't know how many of you got vaccinated. I know that we have a very international audience. I'm based in Washington, DC. I am fully vaccinated. It has been a couple of months since I got my second shot, but I know that that's not the case for many people. I am one of the privileged ones because I live in the US. And, you know, and when you look at this map, you see that, like, you know, most of you who are in the UK are also privileged as we are in the US, because like by late 2021, like you can expect that 60 to 70% of your adult population will be vaccinated. But that's not the case for many other countries. And you can see that the global vaccine timeline stretches to 2023 in most of the global south, especially in Africa and some of the Latin American countries. So this is the current landscape. This is the challenge we have. So the problem is not that we don't have the vaccines. We have the vaccines and the science has delivered. We have these great vaccines, these mRNA vaccines, and also like antiviral vaccines. But the problem is business as usual. We have like IP barriers and we have limited manufacturing capacity. And some of you will say that, no, that's not about the IP, but it is about the IP, because this is a chicken and egg problem. You know, we have like limited manufacturing capacity because of the IP barriers we built over the years. So talking about IP barriers, let's focus on the capacity issue first. When we look at the pre-COVID vaccine production, we can see that like the pre-COVID vaccine production is only limited to 5 billion doses. So like at the end of 2021, in order to vaccinate 75% of the population, we have 11.5 billion. We need 11.5 billion doses, and the pharmaceutical industry has committed that they will deliver us 9.5 billion by 2021. That's really great. It looks so great on the paper, but we still need 2 billion more, even if like pharmaceutical industry delivers the 9.5 billion doses. So the problem is like the same pharmaceutical industry also committed to deliver 837 million doses by the end of 2020. And they only delivered 31 million doses by the end of 2020. So the problem is like things happen, you know, even in the US, we had problems with the emergent emergent biotech. The doses from emergent biotech were faulty, so the FDA hasn't approved those doses. And then pharmaceutical industry tends to overcommit doses. That's what we saw over the years. But when we look at the vaccine producers, the map of the vaccine producers, there are 3 countries: China, India, and the US are the biggest vaccine producers. I mean, interesting thing is like China has been providing vaccines for the most of the global south. 2 Chinese vaccines, Sinovac and Sinopharm, have been widely used by the countries in the global south. And the US, until very recently, has been manufacturing for the US population, because US clearly prioritized the US population. And India, unfortunately, like the solutions we had, especially the solutions that we developed over the course of last year for developing countries, such as COVAX, relied on India for the supply, in order to supply to developing countries. But it didn't work because India has 1.2 billion people and they want to keep the vaccines for those 1.2 billion. So the Indian government introduced export ban for the vaccine doses. So like most of the countries in the global south, they couldn't receive the doses that the COVAX committed to distribute in the first and second quarter of the 2021. Okay, coming back to our subject or discussion subject, the IP barriers. So what are these IP barriers? Like why everyone is concerned about IP barriers? So in order to produce this vaccine at these vaccines at large scale, there needs to be effective technology transfer. And then when I talk about the vaccines, like I'm particularly focusing on the mRNA vaccines. mRNA is a new technology for us, but it's not a new technology. There are scientists all around the world who have been working on this technology over the decade, over 2 decades. But the most successful vaccines today are mRNA vaccines, and IP barriers are very, very critical for these vaccines. And it's not me saying that, it is the companies saying that. So we did a patent landscape analysis of these vaccines back in November when they first proved to be efficient. And then what we saw was like, yeah, they have patents. They have patents on this technology, not necessarily on this vaccine, but on the technology on mRNA platform. But they also have like trade secrets, which they've been relying on. So we went through the Security and Exchange Commission submissions of these companies. If you ask me what's that, it's the financial documents that they submitted to their investors. And they were saying that, yeah, IP is very, very important for us. Not only patents, but we also rely on trade secrets, know-how, and technology, which are not protected by patents to maintain our competitive position. So there are IP barriers, and it's confirmed by these companies. Just to provide you a better picture of these IP barriers, this is an article that we published last month in the Nature Biotechnology. It's a network analysis of the patent landscape, mRNA patent landscape. And so we didn't only look at the patent applications or the existing patents. We went through all the Security and Exchange Commission submissions of these companies to identify, to come up with a network analysis. And this is what we came up with. So as I said, mRNA is not a new technology. I mean, maybe it's new for us, but it's not a new technology. There are like there are scientists who have been working on this, and it is invented by a researcher in University of Pennsylvania, UPenn. And UPenn owns the main patents on mRNA platform, and then it's sub-licensed to other companies. So you can really see like a very complex web of intellectual property protections over the mRNA platform here. And the issue is like there are like sub-licenses, and there are like ongoing like litigation. There are ongoing lawsuits between these companies for patent infringement. So the network analysis shows us that like, you know, it is very, very complex, and this also provides an answer to that argument that, yeah, there are compulsory licenses, like, you know, countries should issue compulsory licenses for these vaccines. It's not that easy. You know, how many compulsory licenses will you issue? And I have to say, this is what we identified, and I'm not saying that this provides us the clear picture. There were many like statements in those records which were redacted. So like I am sure there are more patents and there are more patent applications involved in this picture which we couldn't identify, or they didn't exist back in December 2021, and there's a new application now. So we don't know, but current like the picture is this. And it is very, very complex. So what is the solution? I mean, we've been hearing many people, especially the industry, saying that the solution is the voluntary licenses. Like we are ready to transfer this technology. I mean, first of all, the biggest concern about these voluntary licenses is like, we don't know the terms and conditions. I mean, companies don't publish these licenses that they grant. So these are a few provisions from Moderna's contract with Lonza, and I have to say, Moderna published that contract, but most of the contract was redacted, so I could pick up some of the provisions. But as you can see, this is contract manufacturing, not the technology transfer. Moderna is not transferring technology to Lonza. Moderna is contract manufacturing Lonza to produce this vaccines, Moderna vaccine in Switzerland. And the terms and conditions are very restrictive and also redacted. So the question is, people or profit? Science delivered. We have the vaccines. And how we can get these vaccines to the arms of the people, especially to the arms of the people living in the global south. That's the question. And then we have a solution at hand. Either you like it or not. But the TRIPS waiver proposal removes these IP barriers. It addresses these IP barriers and provides legal certainty and full freedom to operate for the countries. Countries have been asking asking us, the global community, but also the WTO members, and saying that, hey, we have some capacity. We believe that we can manufacture this vaccine, but let us do that. Let us help ourselves. And what we are saying, no, no. And it is very interesting. There have been very interesting discussions taking place related to waiver. I heard like many arguments against the waiver, but I just want to share two statements here, I think, which will really guide this discussion. The president of South Africa, he clearly states that we have the capacity. Give us the waiver. We are just asking 3 years period to enable countries which have the capacity to be able to produce this vaccine, nothing more. It's that simple. And then this is another statement. There was a very interesting interview in the Nature with Kiat, I can't pronounce his surname, sorry, with Kiat Rusgrund, like, sorry, Thai people, I can't really pronounce the surname, but the Thai mRNA researcher, they are working on Thai mRNA vaccines. And he's saying that the waiver would allow us to use technologies that are currently unaffordable or inaccessible to us, make our vaccine even better and cheaper. So, you know, as I said, mRNA research is not something particular to the US or the EU. Like, there are mRNA researchers all around the world who have been working on this platform before it became popular. And they are saying that we really need to use these technologies so that we can either manufacture or develop our own vaccine. And the good thing is, the US supports the waiver. Usually in IP discussions, I have always been the one like, oh yeah, like US. But now, like, I have the honor to say that the US supports the waiver. US population, like the US, like US population agrees with the waiver. US, like, citizens agree with people. US community agrees with the waiver. US president agrees with the waiver, because this is a statement from the President Biden, and it is very clear, you know. And I'm not adding anything. I'm just reading you his words. My administration supports efforts to temporarily waive intellectual property rights for COVID-19 vaccines, because over time we need more companies producing life-saving doses of proven vaccines that are shared equitably. Nothing more, nothing less. We support the waiver. And apart from the US, 100 plus countries support the waiver, because we believe that we can save those people and we can get those jobs, we can get those shots to the arms of, like, the people living in the global south who won't have access to these vaccines before 2023, but we need to address the IP barriers and lift the IP barriers and waive the IP protections for COVID-19 related products and health technologies. Thank you very much.
Burcu, many thanks for your presentation and keeping time. As Ankara University, we are very happy to see you again, and we are always proud of our alumni like you. The issues of waiver came to the spotlight in the aftermath of the pandemic in particular, and Burcu has summed up the development since then. Let's move on with our second panelist now, Dr. Luke McDonough, Assistant Professor of Law, London School of Economics and Political Science. The floor is yours, Luke, please.
Thank you, and thank you, to both institutions for organizing this debate. It's really a vital one right now. As Burcu said, we are faced with the problems of insufficient vaccine production and unequal distribution. Ideally, we would have solved these problems via voluntary solutions, but we must admit that up to now, these have failed the Global South. The voluntary COVAX donation scheme has administered less than 90 million out of a promised 2 billion doses. The voluntary CTAP hub of the WHO for knowledge sharing has been ignored by pharmaceutical companies. If you go back now and read the October 2020 report by Human Rights Watch on the need to share vaccines, it makes for scary reading. The Global South knew in 2020, even though the WHO had recommended vaccinating all healthcare workers worldwide as a global priority, that they would nonetheless be left to their fate in 2021 without adequate vaccine supply, even for healthcare workers. This is the context in which the waiver proposal was made by India and South Africa. This TRIPS waiver debate is now, without question, the most important international intellectual property issue for a generation. When more than 100 countries, primarily those in the Global South, are calling for a TRIPS waiver, we as IP scholars must listen and we must respond. And we must not be defensive in our response. The call for a waiver is not an attack on us personally, nor is it an attack on our profession or on the concept of intellectual property. We must understand that the call for a waiver comes from those for whom the status quo has failed. We must not defend IP uncritically by claiming that the COVID-19 vaccine inequity crisis in the Global South has nothing to do with IP. It does. Like it or not, the IP system is part of the status quo. When manufacturers such as Teva in Israel, BioLice in Canada, Bavarian Nordic in Denmark, and Incepta in Bangladesh have sought IP licenses to produce vaccines and have been refused, or who have offered productive capacity and been rebuffed, we cannot in good conscience say that the insufficient global production of vaccines has nothing to do with the power of IP holders to refuse such offers. When lower income countries such as South Africa, Uganda, and Bangladesh have reportedly been charged higher prices than rich countries for the Oxford AstraZeneca vaccine, we cannot say that IP monopoly power has nothing to do with pricing inequalities. And when this monopoly pricing power offers incentives to manufacturers to sell high-priced booster doses to rich countries, rather than first doses to lower and middle-income countries, we cannot say this has nothing to do with IP. And when we know that within many of our own lifetimes, countries such as Germany until 1968, Japan until 1976, Switzerland until 1977, Spain until 1992, as well as India and Brazil up until TRIPS, built up their pharma capacity in the absence of pharma patents, we cannot say that IP always offers the right incentives to build up capacity. Knowing this, and knowing that IP is a problem, not the only problem by any means, but still a problem for boosting production, the case for the waiver is in principle compelling as a way to create the right combination of incentives and mandates to end the pandemic. In short, the waiver gives the Global South leverage. To argue against the waiver and defend the international IP system against the claims of the Global South is to defend a status quo that has failed and continues to fail the Global South. Whether intentioned or not, this can often read like a defense of the powerful against the weak. My colleagues Shiva, Hyo, Graham, Ashling, and I have written a long working paper explaining the case for the waiver in principle and in practice. We deal with all of the major issues from patents to trade secrets to data exclusivity and regulatory data. I cannot give all of the details in this short presentation, but the entire paper is on SSRN. It's freely available. Please read it and engage. We argued for the waiver as part of a reevaluation of the current TRIPS framework and its effects. We argue that the current IP framework is inadequate for addressing a civilizational challenge, such as COVID-19. For instance, we cannot claim that the compulsory licensing system provides an adequate practical solution when it has been proven to be slow, burdensome, and problematic, product by product, country by country, as shown by Bolivia's current attempt to use Article 31 bis, which has only ever been successfully used once before by Rwanda in 2007, to import from BioLice, which, as I mentioned, was refused a license from Johnson & Johnson. On trade secrets, we argue for a combination of incentives and mandates. Companies should be encouraged, even paying them if necessary, to enter into voluntary technology transfer agreements to the existing WHO CTAP system, and of course, the newly announced mRNA technology transfer hub in South Africa. The public pressure and media attention generated by the waiver is already pushing governments and pharma companies to do more to boost production. The US Biden administration is pursuing this carrot and stick approach. The administration is paying Pfizer for 500 million doses while also pursuing the waiver at the WTO. Carrot and stick, incentive and mandate. This is how the waiver is already helping to achieve a solution. The world's most prestigious scientific publication, Nature, recently backed the waiver, giving us the incredible honor of citing our research in doing so, noting that out of a promised 11 billion doses, at the most 6 billion will be produced this year. Companies keep missing their targets. AstraZeneca and Johnson & Johnson have missed almost every target they have put up. CureVac will produce precisely 0 usable doses in 2021. The experience of the last year tells us that left to the status quo, neither the market nor voluntary action will solve this problem. Indeed, the WHO's independent panel for pandemic preparedness and response makes a recommendation which we support in our paper. It appears to envisage precisely what we're arguing for, utilizing the waiver as leverage by legal threat. The panel recommends that the WHO and WTO convene with the relevant parties and seek voluntary agreement to facilitate technology transfer and voluntary licensing for COVID-19 vaccines. And in the absence of this agreement within 3 months, a TRIPS waiver should come into effect immediately. Currently, there is no legal incentive or mandate for key players to see this crisis as an opportunity to articulate a more equitable and ethical mode of practice of global solidarity. That is why the TRIPS waiver, rather than the current burdensome compulsory licensing system, is needed. The alternative is the status quo, nationalistic and opportunistic behavior, and the quest for what the Serum Institute's CEO has called super profits, as well as the inequalities of production and distribution. Beyond a legal text, the TRIPS waiver has become a masthead, signaling a lot of different kinds of political economic actions that now need to flow. We need a multi-pronged approach, addressing the over-ordering and hoarding of doses in rich countries, coordinating supply chains to increase production globally, investing in CTAP and the new mRNA hub in South Africa, streamlining regulatory approval processes and sharing exclusive data from regulatory dossiers. All of this now has to happen simultaneously. If we do this right, the broken technology transfer promise of the TRIPS agreement can now be fulfilled. To do this, we must interpret and understand intellectual property law in its original broader public purpose. Patents are not ends in themselves. They are a means to an end, a public good. In the midst of a pandemic, we argue that good can be better served globally by utilizing the threat to waive patents and IP rights. Unlike human life, IP rights are not, nor have they ever been, inviolable. That we have several viable vaccines is an outstanding human achievement, but our collective failure to share the vaccines ought to shame us into action. Resolving the global vaccine production and supply problem is a matter of extreme urgency. It is a tremendous challenge, but it is not insurmountable. The waiver provides the necessary leverage for doing this. We cannot be silent as IP scholars. We must seize this moment and offer the waiver our support. Thank you for your time.
Burcu, you are muted.
Okay.
Sorry, Arzu.
Okay, look, thank you very much. You have provided an overview of the arguments in favor of and against the waiver. We have obtained very valuable information. Let's move on with our third panelist now, Dr. Dani Cadillo Chandler, postdoctoral researcher, University of Turku, and visiting professor, Lewis School of Law. Please, Dani, the floor is yours.
Thank you. I will try to share my screen. If not, then I will continue without the slides. Let's see. Okay, so good afternoon, everyone. Thank you for joining us, and thank you, Professor Duncan Matthews and Arzu, for this kind invitation to talk about this topical issue. I know it looks that I have many slides, but I'll try to fast forward to keep the message short and the idea that I want to push through within this presentation. So having said this, what I want to talk about today is data exclusivity, and that it looks as an IP Trojan horse in the making. And the reason that I have given the title to this presentation is because although data exclusivity within the TRIPS agreement does not seem to be harmonized as it stems from Article 39.3 specifically, it does behave as a property right to an extent when we look at it from the perspective of the pharmaceutical regulation. So this slide is only for to show some of the distinctions between trade secrets and data exclusivity, because as you know, the IP waiver as proposed within the World Organization is proposing that the parts sections 5 and 7 that relate to patents and undisclosed information that relates to both trade secrets and undisclosed and test data protection not to be enforced for a period of 3 years, according to the new draft for the waiver that was introduced on the 21st of May. So what is the challenge with data exclusivity? One of the challenges is that it falls within the scope of intellectual property rights, but is not an intellectual property right, or is an intellectual property rights of sorts. Additionally, it is different to any other intellectual property rights and is similar to trade secrets in essence, because we don't need an application for this to obtain data exclusivity, as is a right that comes attached to the marketing authorization. And as you well all know, every pharmaceutical product within the European Union, or any country for that matter, requires from a marketing authorization to enter the market. Most of the COVID vaccines, as we know them, they've been within the European context, they need to be approved through the centralized procedure. What this means is that with a single application, the product can be introduced within the whole single market. Therefore, and this is one of the challenges with compulsory licenses in essence, which means that compulsory licenses are national rights. And a national right cannot override this single market application. And that's one of the first challenges. This is why I move forward a little bit to my conclusions in saying that the waiver, although it may not be perfect, it is a good tool to foster more collaboration, and perhaps is a better solution than looking at a compulsory license in itself. But coming back to the marketing authorizations, and this specific regulate or this specific provision that comes from outside the intellectual property rights system, that meaning the pharmaceutical regulatory framework, no medical product or any not therapeutical, diagnostics, or medicinal product for human use or veterinary use can be placed in the market without the pertinent marketing authorization. One of the questions is that, considering that marketing that vaccines for, or in this case, I'm limiting the presentation to, or I'm limiting the scope to COVID-19 vaccines. Since vaccines require from this marketing authorization, and in essence, neither the regulatory institution, in this case, the European Medicines Agency, nor generic manufacturers can use the products that have obtained marketing authorization as a reference to continue introducing products in the market. How is the data exclusivity working in this case? Data exclusivity is completely separate and different from patent term protection. And with this graphic, I quickly want to illustrate how does it work. The term of patent protection is 20 years, as we know, and the time to obtain a patent in the EU takes between 8 to 10 years. And a marketing authorization in normal circumstances may take similar amount of time. So data exclusivity enters in the spotlight to prevent, not to take care of the innovative aspects related to the pharmaceutical innovation or the vaccine in itself, but to protect the product that is being commercialized from competition for a particular period of time. In Europe, this is known as the 8+2+1 rule, which basically means that for a period of 10 years, for a period of 8 years, no product can be used, or no product or pharmaceutical dossier can be used as a reference to obtain marketing authorization for a subsequent product. And if it's used after these 8 years, it cannot enter in the market before a term of 10 years has elapsed. So now we're talking about during this time where we need more products to enter the market as fast as possible. If we have data exclusivity in place that comes attached to the marketing authorization, whereas has been granted for emergency purposes, as most of these COVID vaccines marketing authorizations have been granted, how can we generate not only competition, but in this case, we're not interested in generating competition, we're interested in supplying the market to tackle an issue that is affecting us, that is bringing the whole world to a stop. So, and this is the tricky issue with data exclusivity. According to the regulation, the product can be used, or a previous application can be used as a reference when 3 cumulative conditions have been met. And the most important one is that the relevant data exclusivity period has expired. But what if it has not expired? What do we do? Then we have to resort to voluntary licensing agreements, but have they been taking place? Are we actually using this? And this refers or connects to the previous presentation from Luke when he mentioned that Teva tried to obtain a voluntary license to manufacture the COVID-19 vaccine with the major pharmaceutical industries that are doing this, or companies that are doing this at the moment, and Teva was not successful in obtaining this voluntary license. So what do we do? What is the solution? If no voluntary license or agreement will take place, then there needs to be, according to the national law, some sort of exception to bypass this data exclusivity period. At the moment in Europe, we do not count with any exception on basis of public health or a major public health interest, which ironically is a term that shows constantly within the European Medicines Agency dossiers and guidance rules, and within the regulation in itself, the pharmaceutical regulation. However, when we go into the European Medicines Agency webpage to check which are the medicines or which are the vaccines that are actually within the market, we only find that 4 vaccines have been approved and only 4 more are currently under rolling review. And how many of these are biosimilars? And why do I say biosimilars and not generic products in themselves? Because for vaccines, one of the arguments that have been made within the opposing papers to the waiver is that no generic can be placed because can be considered a biosimilar to vaccines because vaccines are biological products. Therefore, the differences with a generic manufacturer and biosimilars in themselves is that a biosimilar cannot really rely on a already known active ingredient or a formulation or use a dossier as a reference, because it will still need to comply with clinical trials, since these products will slightly differ in their manufacturing process in opposition to what a generic would be. Nevertheless, the question emerges again, why Teva did not obtain a voluntary license or an agreement with the other manufacturers to be able to supply the national market or supply or help providing vaccines for the global south. Since we're continuing to Europe, and this is also one of the exceptions, there is this rule of confidentiality and then the public interest that becomes an exception to continue bypassing proprietary rules or this traditional or strict no disclosure that data exclusivity should follow. Interestingly enough, the European Medicines Agency has decided to increase transparency and that in exceptional measures for COVID-19 vaccines is beginning to disclose as much information as possible because it's considering there is an overriding public interest. And the emerging question again is, if there is an overriding public interest to disclose this information under exceptional circumstances, why aren't there sufficient generic manufacturers taking place in the market, or participating in the market as well to help supplying the vaccines? By no means I'm saying that data exclusivity is the only challenge or the patents are the only challenge in addressing the scale up of the vaccines. No, there are additional challenges and no one is denying that. However, we must acknowledge that there are legislative roadblocks to satisfy the market, the needs of the market and the population at this point. So the challenges in relation to the World Trade Organization waiver and data exclusivity regime in itself is that data exclusivity or test data protection is not harmonized within the TRIPS agreement as such, meaning that through the TRIPS agreement only demanded, as shown in the first slide, for the protection of this test data as against unfair commercial uses, and the limit was that. But what is to be considered an unfair commercial use within the context of the European Union? Can we say that at this point, allowing access to test data protection and granting marketing authorization for biosimilars constitutes an unfair commercial use? That's one of the biggest questions that comes to my mind continuously when I think about the challenges related to data exclusivity. Additionally, Article 39.3 provides for an exception that seems to require recognition through domestic law. And that exception is that the protection and the disclosure of the test data or in normal circumstances takes place, except when it's to protect the public. In this case, we are in an exceptional circumstance where we need to protect the public. Since that exclusivity was not harmonized within the TRIPS agreement, it has been up to bilateralism or bilateral free trade agreements to increase the protection and determine how test data should be protected within the countries that are using this sui generis system of protection. And this sui generis system of protection in most countries or outside the European Union has required for the data to be protected for a period of 5 years. If there is no exception within the national legislation, meaning the pharmaceutical regulatory framework, then this data protection cannot be bypassed. There is no way to do it because it's outside the scope of the intellectual property rights system and is not up to the intellectual property rights system to decide the flexibility that goes accordingly. Even if TRIPS allows for the use of flexibilities such as compulsory licenses, these are not reaching to data exclusivity because of the same reason, because TRIPS only demands that is protected against unfair commercial uses. However, is not sufficiently, it has not been implemented similarly in every other member state. The IP waiver as proposed is not perfect, as I have mentioned before, but the current system is not perfect either. And the IP waiver seems to be a tool in the right direction that would allow for further collaboration, or at least it seems that because, and this is a bit anecdotal, but the waiver sounds better or sounds more like a curse word than compulsory licenses before. Before we were all terrified, or we were all not, but most were terrified of compulsory licenses. Now compulsory licenses do not seem to be that scary anymore. So that may be a positive thing as well. And that exclusivity can only be circumvented if a voluntary agreement takes place. And the question remains then, why couldn't Teva reach an agreement with major manufacturers? So thank you for your attention. If you have further questions, I'll be happy to take them.
I would like to extend my thanks to Dr. Deney, for her illuminating presentation, highlighting data, market exclusivity, and their prominence in the waiver. Now I would like to move on with the last presentation, Professor Dr. Duncan Matthews, Director of the Queen Mary Intellectual Property Research Institute, Queen Mary University of London. The floor is yours, Duncan.
Thank you, Arzu. I'm just going to share my screen because what I would like to do in the remaining time is to try and synthesize and bring together some of the themes that we've heard during today's presentations. So I think it's important just to set out at the outset exactly what a waiver of the relevant provisions of the TRIPS agreement would do. So we know that the India-South Africa proposal refers specifically to the protection of copyright, of industrial designs, of patents, and of confidential information in the specified parts of the TRIPS agreement. And we know that the US has indicated that it would be prepared to enter into text-based negotiations about how such a waiver of the relevant provisions of TRIPS would be operationalized. If and when a waiver is achieved, this would give WTO members the discretion to deviate from their obligations to protect and enforce minimum standards of IP protection under those parts of the TRIPS agreement. So that's, in a way, sort of procedurally, what the discussion about a legal IP waiver at the WTO TRIPS Council would entail. However, if we actually look at the provision of the TRIPS agreement, which would be relevant, if at the ministerial conference, which is scheduled to take place on the 30th of November until the 3rd of December this year, procedurally, this would be the forum in which such a waiver would be formally implemented as a legal document of the TRIPS agreement. And you'll see that in the WTO agreement, which came into force, of course, in 1995, that this is the provision in Article 9, paragraph 3, which provides the opportunity for such a ministerial conference of WTO members to decide to waive an obligation. So the pathway that we are on in terms of the negotiations for a waiver at the WTO is headed in this direction towards a ministerial conference. However, do the supporters of the waiver, that's to say the WTO as a member-driven organization, offers voting rights to each of the WTO members, do they have the numbers to achieve this? So there are some misconceptions, I believe, in the wider discussion about how this would actually take place. Much emphasis has been put on the need to achieve consensus of all 159 WTO member countries, including the European Union. But in fact, when you read Article 9, paragraph 3, it doesn't talk about the need to achieve consensus. It talks about the possibility to take a decision to waive provision of one of the WTO agreements by a vote by 3/4 majority. Now, whether we ever get to the stage where such a vote is necessary at the ministerial conference remains to be seen, but I think it's important to sketch out the legal pathway for achieving this. Reading on in this provision in Article 9 of the WTO agreement, in paragraph 3, it then talks specifically about how such a waiver would be operationalized. So the discussion which is now taking place about, well, we have to reach consensus of all WTO members, and certain WTO members, such as Germany, such as Switzerland, would block such a consensus. Well, in fact, under Article 9, paragraph 3, it's possible to take such a 3/4 vote. So one of the things which is being discussed in the corridors of the WTO in Geneva is the fact that, well, do the supporters of the waiver as WTO member states, do they have the votes? So with 159 WTO members, we would essentially be talking about something like 120 votes would be required from WTO members to get to that 3/4 majority to formalize a waiver of these provisions of the TRIPS agreement. And the last slide I'll show you from the WTO agreement in terms of what next really shows you the specific role for the TRIPS Council of the WTO. Now, at the TRIPS Council itself, and we have an informal meeting coming up of TRIPS Council in the next few days, the TRIPS Council itself is not required to take a vote. That vote will be taken separately, ultimately at the ministerial conference. So that then takes me to what the role of the TRIPS Council will be. We know that there has been an amended draft text tabled on the 25th of May by India and South Africa, following up their initial proposal for a waiver from the 2nd of October last year. Well, in fact, it's instructive to note that really the key role is the role which is going to be played by the General Counsel of the WTO. And this is a screen grab from the WTO website from yesterday, which shows that the chair of the General Counsel, Mr. Castillo from Honduras, has selected now, if you like, a special negotiator, Ambassador David Walker from New Zealand, who is going to try and facilitate the WTO response for COVID-19. Now, of course, this doesn't speak specifically about the TRIPS Council, but I think we can imply that the TRIPS Council would be the focus of this attention as we move towards text-based negotiations on a waiver of the relevant provisions of the TRIPS agreement. Also key to this role will be the chair of the TRIPS Council, the ambassador from Norway, Ambassador Surlin. And essentially what will happen is that perhaps after the forthcoming TRIPS Council meeting, or perhaps as late as October, the ambassador of the from Norway, who chairs the TRIPS Council, will essentially communicate to the chair of the General Council of the WTO what the discussions have ultimately resolved or not resolved. So there's no need for the TRIPS Council to achieve consensus. There's no need for them even to take a vote. There will be a communication to the chair of the General Council, and it will be the chair of the General Council of the WTO, together with the special rapporteur on the WTO and COVID-19, who will be working hard, we suspect, to prepare a document which will go to the ministerial meeting, MC12 meeting, which will take place on the, which will commence on the 30th of November. So whether we like it or not, the WTO is a member-based institution. It's a member-driven based institution. So at the end of the day, whether I or others support or are against the waiver becomes irrelevant, because the consensus or the vote will be taken by WTO members. So if we do have a decision of the WTO by the end of the year to waive specific provisions of the TRIPS agreement in response to the COVID-19 pandemic, what might then be the pressure points? I began by saying that effectively that waiver would give discretion to WTO members, to governments, to set aside their obligations, for example, for patents, for confidential information such as regulatory data or know-how and trade secrets. Now, there was a very interesting resolution passed on the 10th of June this year by the European Parliament, which sets out and sort of synthesizes a number of kind of pragmatic, practical approaches. And I think one of those pressure points, faced with the threat of IP waivers, I think the current positions of the vaccine manufacturers who are holding IP and other relevant technologies, if that's regardless of whether that's diagnostics or therapeutics, will move their positions. I believe that the benefit of an IP waiver would ultimately be the pragmatic one, that it will put the IP owners in a position where we will start to see greater transparency in the voluntary licensing agreements, which are currently not in the public domain, or when they are heavily redacted, or also the advanced purchase orders that the European Union and other institutions are putting in place to purchase those vaccines. And without transparency for publicly funded research, which is essentially what most of the vaccines available are, we're allowing confidential information to be treated as a type of IP by the proponents of the fact that a waiver should not be brought into effect. Another pressure point, which I think we'll see, is one of competition law. And you'll probably be aware that in April last year, at the beginning of the pandemic, the Swiss company Hoffmann-La Roche was under investigation by the Netherlands Authority for Consumers and Markets, the ACM, which is the competition authority in the Netherlands, about the way in which the buffer, which is used in antigen tests, was not being protected necessarily by patents, but was being protected as a trade secret. And this was considered by the Netherlands Authority an abuse of the dominant position that Roche had for this particular buffer, which is used in antigen tests. And as a result of this pressure point, a competition law successfully was used to put Roche in a position where it was making this buffer more widely available. So I think the anti-competitive practice is not just for registered types of IP like patents, but also for trade secrets, tacit knowledge, etc., will become more relevant in the future. And sticking with Roche, I just wanted to make a point, and this isn't a point specific to Roche. Roche is not a vaccine manufacturer, and it doesn't own IP on the vaccines. but I wanted to make a general point about the public relations exercise being conducted by global pharmaceutical companies. As you can see from this headline from the Financial Times newspaper from May of this year, the chief executive of Roche was comparing the proposal to waive vaccines with East German nationalization of the pharmaceutical industry. And if any of you are familiar with the illegal testing which took place by Roche during the DDR regime without the consent of people who were administered medicines by Roche, then there is a complicated history that Hoffmann-La Roche has with East German nationalization of the pharmaceutical industry. And I just wanted to use this. I could have chosen other examples from Sanofi or Pfizer or many other pharmaceutical companies. I would like to know who is running their PR machine, because it seems entirely counterproductive to use Mr. Schwan's own subheading from the Financial Times. I'm going to conclude with this slide. 2 days ago, on the 23rd of June, the World Health Organization announced that it was setting up the first of the regional vaccine technology transfer hubs that Luke McDonough has already referred to. Why is this significant? If we look beyond patents, if we look beyond regulatory data, it's often stated, but also often contested, that it's far too complicated to make these vaccines, particularly the mRNA vaccines, that you would effectively need to send somebody from the production line of Pfizer or Moderna or Johnson & Johnson, and that individual who has this tacit knowledge inside their heads about how to run the production within the manufacturing facility would need to pass on that information by physically going to WTO countries who were setting up manufacturing capacity. Now, whether that's true or not, and as I said, it's contested, surely the advantage of a technology hub is that you can localize and regionalize that transfer of tacit know-how about the manufacturing of the vaccines in a central resource for a particular region. So at the end of this press release from the World Health Organization, it points out that this is just the start of setting up the regional hubs for mRNA vaccine manufacture. And my final point would be about pandemic preparedness, because this, of course, will be essential as we prepare for future pandemics and reflect on the mistakes of the COVID-19 response. Thank you.
Dear Duncan, you have provided an extraordinary synthesis of the topics covered today and provided insights into the potential solutions. Thank you very much. I think we have almost run out of time for today's conference.
Arzu, no, how are we doing? We have until past. So we have.
Yes, I know. Yes, I know.
Okay.
And, apparently, these issues are going to cover our agenda for a much longer time. I hope we are going to get out of this pressure posed by the pandemic soon. On the other hand, obviously, we are going to maintain this discussion over the role of IP rights in context of the new technological developments, other epidemic diseases, treatments, pharmaceuticals. We have a large number of attendees today, so in order to stick to our timetable today, I would like to move on with the question and answers. For those who wish to raise questions, if you could kindly indicate the panelist or panelist that you would like to address your question, comment, I would be grateful. But all panelists can answer the questions, of course. I see some questions here. And for example, Louise would like to have the link to Luke's paper. Okay, Kang gave this link because Luke is one of the co-authors of the SSRN paper in the subject. And from Turkey, there is a question, Nazlı Johnson Karga. Don't you think that there should be safeguards in place to protect the patent owners if the vaccine patents are waived for a period of time, given that private generic manufacturers will access the teaching and the knowledge? These manufacturers may try to take advantage of this post-pandemic, and this could potentially delay the emergence of new products using these proprietary technologies. It's a question.
I can start off
Okay.
with an answer and then hand over to my fellow panelists. As Burcu was explaining in her excellent presentation, most of this mRNA foundational technology is not new technology. So one of the concerns, of course, of the IP owners is that by releasing this IP, and particularly the know-how and the trade secrets, once that is out there, it's difficult to get it back, even if you have a time-limited waiver. So whether this is correct or not is a matter of debate, but one of the arguments which is put by the manufacturers is that once this is in the public domain, we can never get it back. So that is one of the concerns which Kansin has highlighted in her question. But I'll hand over to my other panelists because I'm sure you will have views on this also.
Yeah, I like to chime in on that because this is one of the arguments we've been hearing from pharmaceutical companies, and it's very interesting. Like, I've been working on access to medicines on the ground with most of the global South countries, like for more than a decade now. And one of the arguments we heard all those years was, we need IP protection for innovation. IP promotes innovation, and we really believed in that, right? We had all these precious IP protections. Remember, back in March 2020. So when WHO declared pandemic, COVID-19 pandemic, did we have treatments to treat this disease? Did we have vaccines to prevent? No, but this wasn't the first like coronavirus. This is the third time coronavirus leaped from animals to humans. And first time in 2004, SARS, and then MERS in 2012, and finally COVID-19 in 2019. And all this time, the pharmaceutical companies had the precious IP protections to prepare us for the pandemic, but they didn't because there was no market. There was no, because SARS and MERS affected only Southeast Asia and Middle East, and there wasn't a big market. So all those years we heard this argument, we need IP for innovation, pharmaceutical innovation, and you had all the IP, but you didn't invest. So I think in this case, this argument will not work, because in March 2020, we had nothing. And as I said in my presentation, science delivered. Today, everyone wants mRNA vaccine. And one thing about mRNA, there was a very great article in the New York Times with the inventor of the mRNA platform, a Hungarian researcher, and she was saying that no one supported my research. I relied on public funding. Big pharmaceutical companies, they didn't have interest in this. So as public, we funded this research. It's our money, it's the taxpayers' money. It's the taxpayers in the US, it's the taxpayers in Europe. We funded the research. And you may remember from my presentation, there was a slide, the network analysis. And when you look at the network analysis, you see all these small companies, not the big pharma. Pfizer is there just because Pfizer and BioNTech, they have an agreement. Pfizer didn't invent this technology. It is BioNTech which invented the technology, and we should keep that in mind.
Okay, thank you very much, Burcu. There is another question of Pratipa. Big Pharma says IP is not an issue, but raw materials are. There are only 2 suppliers who already supply to Pfizer and Moderna. So even if waiver comes through, nobody will be using it because no raw material suppliers. What is the panelist's response to it?
Hi, so I'll give this one a go.
Okay.
First. So it's a very good question. And the first response to it should be that we need transparency on raw materials. And one of the benefits of the waiver debate so far has been that it has put the pressure on the right people and on the right companies and on the right governments to create more transparency on, for example, production capacity. So it was very, very common, even let's say 3 months ago, before the US supported the waiver. It was very common for people to dismiss the waiver by saying there simply is no spare capacity out there at all. It does not exist. If you had a waiver, you could do nothing with it. We are at capacity. And the waiver debate, and particularly once the US got on board with it, created such a kind of a media attention zone, I suppose, that reporters started asking questions and started figuring things out. And they figured out that Moderna built its capacity to manufacture mRNA vaccines last year very quickly at some facilities that were not usually used to make vaccines. We also got a lot more transparency once the media started asking questions about companies like BioLice and Incepta and Bavarian Nordic that had tried to get licenses and had been refused. Teva came out and said, we offered our capacity, and that's a massive company. Very experienced generic manufacturer of medicines came out and said, we offered capacity and no one took us up on the offer. So it suddenly became very clear that there was not only lots of capacity out there in terms of facilities, but also that new capacity can be built and can be built within a reasonable time frame. Since that argument has been debunked, and as I said, if you go back to the responses in The Economist or the Financial Times of March, April 2021, that's what the argument was. The argument was there's no capacity. Since that has been debunked, we've had this other argument, which is there is no raw material that we can use. And what's interesting about this is that this was made not long after the US came on board with the waiver, and companies said, that there's very limited supplies of raw materials, and if we allow more capacity, then everybody will be competing over the same raw materials. We won't get more doses. We just won't. It's impossible. There's no raw materials. Very shortly after that, BioNTech formed a deal, which is a very positive thing. We need more doses, with FISAUM in Shanghai to create 1 billion doses. At least that's what their aim is. We now have Pfizer, who have taken up the Biden administration's opportunity to essentially, Biden is buying hundreds of millions more doses. So there's raw materials there for those doses. And if you look at the projections in the Financial Times for what can be produced next year, the raw materials question does not seem to be as big of a problem as it is being made out to be. But what we need is real transparency on that to figure out where are the bottlenecks that we need to resolve. And in our paper, as several other people here, Buju and Duncan, have argued for as well, we need that transparency and we need coordination by governments. And if you go back to what was called for in the waiver in October 2020, the Indian and South African governments, it's there in the MSF report, it's there in the Human Rights Watch report, they're arguing for global coordination of supply chains and access to raw materials so that you can have production in every part of the world, hubs in different parts of the world. So it's certainly an issue. It needs to be resolved, but we need the information in order to make that decision. And we need to keep the pressure on to get that information. We cannot take it as a given that there is no raw material, because actually there's lots of evidence to suggest that it is not beyond the capacity of the world to produce enough raw material to vaccinate the world.
Okay, thank you very much. There are 2 questions from Luis. Should the proposal of the waiver of the TRIPS or introduce as well a waiver for investment obligations and TRIPS? Second question, what do you envision as midway compromise in TRIPS? Something is what we want, other is what could be politically achievable.
I'll take the first question, which is
Okay.
about a specific aspect of this first question is about investor-state dispute settlement. And certainly, I know that this is being discussed amongst pharmaceutical companies, whether they could use investor-state dispute settlement in trade agreements to challenge the legality of waiving IP rights. Most of the agreements which have investor-state dispute settlement, however, have public interest safeguards built into them. So I think it would be questionable. I've been asked this by partners at law firms who represent clients. I think it would be questionable whether this would be successful, but others on the panel might have further comment on that.
Okay, thanks. There is very interesting question from Nico. Question to Luke and Danae. Regarding data exclusivity, what would be your proposal to be done to overcome the data exclusivity obligations which were imposed by the US and EU in a multiple number of FTAs onto developing countries, as the US position makes no mention on any waivers of TRIPS provisions in their FTAs?
I can.
Okay.
Thank you. I can start with this one. Well, this is an interesting question, and is a lesson actually from the global South or Central American countries. And one of the smallest one is Costa Rica, where subsequently, after having a free trade agreement with the US and in the imposition on having data exclusivity, they move forward in modifying or reforming their pharmaceutical legislation and having a specific legislation for the protection of undisclosed information or test data protection. And in this, there is a clause that reads that the data shall be protected against any unfair commercial use and any disclosure, except where the use of such data is necessary to protect the public. Additionally, they do seem to bypass the protection through national legislation and because the TRIPS agreement also allows for member countries to define what is a national emergency, then this exception it fits within the body of the international framework or the statutory provisions requiring for the protection of the data. So in this sense, I would say that the clearest way to do it is through national exception. Domestic law needs to be able to have an exception or needs to contain an exception to make use of this data to ensure that there is sufficient supply. Costa Rica was also quite relevant when the pandemic started by calling for a pool where the data protection was also bypassed to increase transfer of technology and foster for collaboration amongst the pharmaceutical industry to tackle the need for the vaccine. And I also wanted to say that on the incentives regards and connecting to what Borju said before, that true, the IP incentives have been there. And when we talk about the waiver, right now, it seems that we want to avoid the whole patent system forever. No, we're calling for an exception for an exceptional period of time. We're not thinking that these exceptions and that we need to bypass intellectual property rights or we need more further flexibilities forever. We're under extreme circumstances. And the pandemic in itself, in my opinion, has been the driver for innovation, not the incentive in itself. And when we look at it, we look at the pandemic as a driver for innovation. We are also missing by sight that the rest of the diseases are not receiving sufficient research and development at this point. And there was an article about that a month ago or so, that, for instance, cancer research and development for certain carcinoid drugs were not being taken care of at this point. And we need to be consistent. It's not only about the pandemic, but we need also to take care of the other research and development. We need an exception for these circumstances, and I personally think that the addition or the inclusion of these 3 years in this proposal for the draft that is revised on a yearly basis should be a workable solution. It's a compromise. You are not asking for extreme flexibility. We're asking for a revised flexibility that can be done on yearly basis. And this is nothing unusual. In the international trade framework, when exceptions, trade sanctions, or trade barriers are imposed, are revised on a determined period of time to lift them or to extend them. So why cannot we achieve the same thing with intellectual property rights?
Okay, thank you. Dene, there is another question for you from Zuley. As Dene said, data exclusivity is not harmonized within TRIPS and compulsory license cannot reach data exclusivity. So my question is, if in one country the biosimilar drugs are in the data exclusivity period, what can the waiver or the government to do improve the local drug availability? But look, you can answer previous question again. Okay, Danae, we can hear you.
Okay, this part of the biosimilar also corresponds particularly to the design of the pharmaceutical legislation in itself. In Europe, biosimilars would not necessarily, if the biosimilar can prove that it's different to the product of reference, then you need your own clinical trials and you don't need that reference product. So that is an issue of the design of the legislation in itself and the provisions on data exclusivity and the products. If the biosimilar cannot be considered a generic, it requires for its own clinical trials and preclinical trials to be authorized. So that could be one solution. The other solution is again through national exception, and or the other idea that has come through the free trade agreement, or it was the investment agreement with China, as a matter of fact, recognized data protection as an intellectual property right. And if data exclusivity or undisclosed information is recognized as an intellectual property right, then the flexibility and IP flexibility should reach that intellectual property right. But it also boils down to recognizing test data protection or undisclosed information as an IP right, which is not something that has been done at the general level.
Thank you very much. Luke, would you like to say something to Nico's question?
I think Danae's done a brilliant job on those two questions, but I would like to, while we have some time, if you don't mind reading out the question from Tamar and also the question from Fiona, because they're both the same, really,
okay.
both about incentives.
I have a question also to all of panelists. When do you think the impact of waiving of IP rights can be seen and the vaccines can be manufactured? Duncan, maybe you can answer first.
Well, if you don't mind, I'll try to answer these questions that we have in the chat, and then we'll come to that very important one, maybe as the final one, because we have 5 minutes. I'll be quick, I promise. So the question has been about the Max Planck Institute for Innovation and Competition. They put out a paper that says that the waiver IP may have a detrimental impact on incentives. There's also a question from Fiona, which is saying Germany is opposing the waiver on the basis that it would be a detriment to incentives. And it's very important to unpack all of this. And we do that in detail in the paper. So both of you, if you're interested, please read the paper in detail. And we specifically take on the assumption in the Max Planck paper, which is not very well presented and is not very rigorously put forward, in my view, in that paper, because in actual fact, the vaccine market is one that is usually described by health economists as one of market failure. That there are great reasons why we don't have vaccines for certain illnesses like malaria. And we also need to see the current crisis as one in which we need to learn from how the state and public funding has created a market for a vaccine, has funded certain projects to completion. And this can give us a new opportunity for how we fund kind of health innovation in the future. We don't have to simply rely on a model that doesn't always work and works very unevenly when taken in global terms. And if you read the Max Planck paper, they do not actually offer a solution to boost production and solve this problem. So I think that the emphasis here and the obligation is really on those who oppose the waiver to explain how voluntary solutions that have so far failed to resolve this problem can now do it. And I really hope that that is what happens next. Thank you.
Okay, thank you very much.
Could I just add a comment to this, to Luke's excellent summary? One of the points I forgot to mention at the beginning of today's event was today marks the first anniversary of a series of webinars that we had last summer in 2000, at the Queen Mary IP Institute webinars on responses to COVID-19. And exactly a year ago, we were talking about the fact that a repeat play of the Doha Declaration, the use of compulsory licensing, simply wasn't going to work because of the complexity of the technologies involved, the complexity of looking at not only vaccines, but treatments, diagnostics, and ventilators, PPE. So we've been saying this for a year, and as have many others who are on this call. So it's almost quite depressing to read a document, whether it's from the MPE in Munich or from elsewhere, which seem not to have engaged with the reality of the problems. And the last point I'll make is that some of you might have seen the Financial Times opinion, which I published with a German academic who signed the MPE declaration, and that's deliberate. We don't agree, and we're writing together. We're now working on a much longer paper, because I think you have to engage with people who don't support your views, and that's why I think probably the discussion at today's webinar has been so important, because we've had a cross-section of different views discussed in a very helpful and appropriate way to move this debate on.
Okay. There is Fiona has a question, but Luke has almost answered it, but maybe you can comment it. Germany is still opposing the waiver. Argument is that IP is not the issue and companies need incentives to do the research at the large scale as it is needed. What would be your number one argument against that opinion?
I think all the panelists mentioned that this is once in a century pandemic, and we should be able to use all the tools that are available to us. And we try to use those tools, like, we created COVAX, and, I mean, COVAX, it's the problem with the COVAX is it's not that COVAX doesn't have money. The problem is we don't have enough supply. We need to increase the manufacturing capacity so that we get these vaccines on time, on a timely fashion to people's arms. Like, as I said, I'm vaccinated, but most of the people in the global south are not. And this is a problem for everyone. This is a problem for me, and this is a problem for you. And we need to use every tools that are available to us. And the waiver is is one of those tools. Waiver is what those countries have been asking. When you talk to the government officials from those countries, which have been co-sponsoring the waiver, they've been saying that, please give us the opportunity to help ourselves. And I think at this stage, we should be like, we should tell them, please go ahead and help yourselves, because we failed to help you. Like, we prioritize our personal interests, and we failed to help you. Go ahead and manufacture these vaccines. That will be my argument against the German argument.
Okay. And QMIPRI has a question. If the waiver cannot be passed unanimously by the WTO, what is the next best alternative? Burcu or Duncan or Danae?
Well, I'll just sort of reiterate that if there is a vote on the waiver, it doesn't need to be passed unanimously. The procedure that I set out allows for a 2/3 vote. I think perhaps if you don't mind, Arzu, I'll also link this to Huyun Chang posted an interesting question, which we passed over, which was, doesn't the TRIPS waiver not only act as pressure point, but also as a legal lever if passed? Of course, it's the WTO members who take the vote and decide, but isn't the mobilization of public opinion crucial to give the countries the legitimacy to vote in certain ways? And I would agree with that statement, and that's why we have a member of the civil society representation, my former doctoral student Burcu, on the panel, because I think the role of civil society is important in this respect. And of course, we are seeing now, often defensively, WTO member governments changing their position. So I think the debate is only at the early stages, and there will be movement from particular WTO members. So I think the role that public opinion can play in determining whether, coming back to the original question, whether a waiver is passed is an important aspect. But I mean, just to conclude this point by reiterating what I want to see is the scaling up of local manufacturing, improvement of supply chains, and if that can be done pragmatically without a waiver or without WTO members exercising the waiver through their national law and procedure, then great. At the end, it's not the waiver I want to see. I want to see pragmatic solutions to a global problem.
Okay, thank you very much. Dear attendees, with this, we have concluded our webinar today. I would like to extend my gratitude to our panelists who for their very valuable and stimulating presentations, and to our audience who contributed with their questions and comments. I look forward to meeting you for our forthcoming panels and wish you a pleasant evening. Duncan, would you like to say something as closing words?
Simply to thank all our participants. We had an amazing number of participants, around about 100 people participating online, which is amazing. It shows how relevant and important this topic is today. And I thought all the panelists and our moderator did an amazing job. So I think we have contributed substantially to this debate. So thank you everybody for coming today.
Okay, thank you again to you, Duncan, and to our panelists and to our audience. Thank you very much and good evening.
Thank you.
Thank you.
Bye.
Bye.